Hello and a warm welcome to World This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and I will be taking you through the significant orders and judgments passed by various courts in the country and some important international news from this week. Let's begin with Supreme Court this week. Calling it unconstitutional, a 5-judge constitution bench of the Supreme Court has struck down the Electoral Bonds Scheme that allowed anonymous donations to political parties. The highly anticipated judgment, which comes just months ahead of the Lok Sabha election, ruled that the Electoral Bonds Scheme violated freedom of speech and expression under Article 19(1)(a) of the Constitution. Information about funding of political parties is essential for the effective exercise of the choice of voting, Chief Justice D.Y. Chandrachud said while striking down the scheme, which was introduced through the Finance Act 2017. The State Bank of India, SBI, which is the issuing bank of electoral bonds, has been ordered to furnish details of the political parties that received electoral bonds scheme since 2019 to the Election Commission of India, ECI, in 3 weeks. The ECI has been asked to publish such details on its official website as well. The Supreme Court has refused for a second time to ban a contentious new law on the appointment of election commissioners. The court has though added the petition to a list of pending cases on this subject and directed all these to be heard in April, potentially days before a general election. The court has also issued a notice to the central government seeking a reply. The new petition has been filed by the Association for Democratic Reforms, an apolitical and non-partisan non-profit organization working electoral and political reforms in the country. If the operative section of the new law, which states appointments are based on the recommendation of a 3-member committee led by the Prime Minister and including a member of the Union Cabinet and not the Chief Justice of India, remains, Advocate Prashant Bhushan said that the petition becomes ineffective. However, a 2-member bench of Justice Sanjeev Khanna and Justice Dipankar Datta disagreed and said that the matters of constitutional validity are never infructuous and unnecessary. The post of Deputy Chief Minister may not be defined under the Constitution, but there is no illegality in appointing senior leaders of the ruling party of a coalition of parties as Deputy Chief Ministers, the Supreme Court observed, dismissing a public interest litigation that demanded that the practice be struck down as being unconstitutional. According to a bench headed by Chief Justice of India, D.Y. Chandrachud, a Deputy CM is a legislator and a minister called as a Deputy CM, and therefore no constitutional provisions are contravened by this practice. The appointment of Deputy Chief Ministers is a practice followed in some states to give a little more importance to senior leaders in the party or coalition of parties in power. It's not unconstitutional, said the bench, which also comprised of Justice J.B. Pardiwala and Justice Manoj Mishra. Rejecting the PIL moved by Delhi-based Public Political Party, it added that the Deputy CMs under the Constitution are after all just members of the Council of Ministers headed by the Chief Minister. The Supreme Court has issued a notice to the Union Government, including the Finance Ministry and the National Anti-Profiteering Authority, on a case relating to the constitutional validity of anti-profiteering provisions related to the Goods and Services Tax (GST). The case pertains to a special leave petition filed before this SC by Excel Rasayan, which is a manufacturer of dishwasher products, against a ruling by the Delhi High Court that upheld the constitutionality of anti-profiteering provisions. The company has contended that in the absence of methodology, the anti-profiteering provisions are manifestly arbitrary and vague, and hence constitutional validity has to be tested before the Supreme Court. Counsel for petitioner has argued before the Supreme Court that the time limit concerning anti-profiteering provisions cannot be endless, and this will pose significant difficulties for the businesses. The anti-profiteering provisions are manifestly arbitrary as there is no methodology to determine the quantum of profiteering, and with this lack of methodology, there are significant challenges for the companies to determine the quantum of profiteering. Further, it was argued that on behalf of the petitioner that the provisions are vague in absence of any definition for commensurate reduction of price, and this poses a significant problem. The case is likely to have a significant impact across the industry. More firms are likely to file petitions in the apex court on the issue. Now let's have an overview of high courts. The Delhi High Court has said that coaching centers that have more than 20 students should move out of residential areas and operate from commercial spaces. A bench headed by Acting Chief Justice Manmohan Singh, while hearing a petition filed by the Coaching Federation of India, observed that students run the risk of their lives at coaching centers operating from residential buildings that do not have the required safety infrastructure such as 2 staircases. In February 2020, the Delhi Development Authority (DDA) modified its Unified Building Bylaws 2016, UBBL 2016, including coaching centers in the definition of educational buildings. The petitioner's lawyers submitted that under the UBBL, educational institutes are required to have several features such as 2 staircases and a playground, which may not be possible in already existing residential building. She also said that there is a distinction between a coaching center and an educational institute, as the latter offers a degree of diploma at the end of a course. In the petition, the petitioner said that the notification was arbitrary and in contravention of the Master Plan for Delhi MDP 2021 fire safety rules and provisions of the UBBL, which classifies residential buildings up to a height of 15 to 17.5 meter in a low or moderate risk category and exempts some such structures from taking safety authorizations. The Patna High Court, while disposing of a petition filed against the order rejecting the provisional bail granted in favor of the petitioner and directing him to surrender before the court of the learned magistrate, held that the anticipatory bail cannot be granted, directing the parties to lead conjugal life, meaning thereby settlement of the offence under Section 498A of the IPC. The court noted that the precondition of granting provisional bail seemed to be an attempt at a reconciliation of the dispute and mediation of a charge under Section 498A of the IPC and other penal provisions. The court observed that in a criminal case, at an interlocutory stage, the parties cannot be directed to stay together where there was an allegation of mental and physical cruelty. The Calcutta High Court, in a petition seeking interest on delayed payment of the gratuity and arrears pension amount, observed that it was the bounden duty of the state to disburse the gratuity and pension amount on the due date, and if it has failed to do so and has released such amount after unexplained delay, it is obliged to pay interest to the retired employee. The court stated that the right of a retired employee to get his retired dues on the date of attaining superannuation is a valuable right that occurs in his favor on the date of his attaining superannuation, and further, gratuity and pension are no longer considered to be a bounty to be handed out by the state at its whim, and an employee has statutory right to receive gratuity and pension upon retirement. Further, the court stated that if payments of such gratuity and pension is delayed, the retired employee is surely entitled to get some interest for such delayed payment. The Bombay High Court has ruled that the taxable service in respect of services provided or to be provided by the individual advocate for a firm of advocates has been set out to be nil. Similarly, service provided by an individual advocate, partnership firm of advocates by way of legal services are exempted from levy of service tax. It was submitted that the petitioner is a practicing advocate. Further, the petitioner and even the chartered accountant who represented the petitioner was not furnished a copy of the show cause notice. It was contended that neither service tax nor GST were applicable or payable. The Karnataka High Court has held that the procedure prescribed under the Hague Convention and the country's regulations needs to be followed in cases inter-country relative adoption, which requires the parties to first request the receiving country to communicate a mail to the Indian counterpart under the adoption regulations, and within 10 days a certificate and NOC would be issued in this country. It was observed that the inter-country adoption as provided at Hague was to recognize that the child, for the full and harmonious development of his or her personality, should grow up in a family environment in an atmosphere of happiness, love and understanding. The convention further recognized that the inter-country adoption may offer the advantage of a permanent family to a child for whom a suitable family cannot be found in his or her state of origin. It therefore is in the best interest of the child with respect to the fundamental rights of the children and to prevent abduction, sale, trafficking of children. Articles of convention were drawn in nature of declaration on social and legal principles relating to protection and welfare of children with reference to foster replacements and adoption nationally and internationally. Moving on to international news this week. Former US President Donald Trump has urged the Supreme Court to suspend the lower court ruling that he does not have the presidential immunity from prosecution. The report stated that Trump called on the apex court to temporarily block, scattering an unanimous decision from the DC Circuit handed down last week, flatly rejecting his claims for immunity from election subversion charges brought by special counsel Jack Smith. Spain's national court has ratified a ruling forcing Barcelona to pay almost 23 million euros in personal income tax regarding payments made to players' agents. Spain's Central Economic Administrative Court demanded in 2020 that Barca pay the sum concerning payments made to players' agents between January 2012 and June 2015. Barca appealed the decision to the National Court, which has been rejected. The club has said that in a statement that it will now appeal to Spain's Supreme Court. In the end, we have miscellaneous news. A sessions court in Mumbai has dismissed a petition of a woman challenging a magistrate court order over her complaint against her husband and in-laws, observing that a man giving time and money to his mother cannot be considered as domestic violence. Additional sessions judge in the order passed also said that the allegation against the respondent are vague and ambiguous, and there is nothing to prove that they subjected the appellant woman to domestic violence. The National Highway Authority of India (NHAI) has removed Paytm from its list of 30 authorized banks for FASTag services as the company faces regulatory action over alleged violation of rules. The NHAI FASTag is managed by the Indian Highways Management Company Limited. The dispute over Paytm emerged after the Reserve Bank of India (RBI) on January 31st imposed a major business restriction on Paytm Payments Bank, including accepting fresh deposits and doing credit transactions after February 29th. The central bank had in March 2022 barred Paytm Payments Bank from onboarding new customers. RBI informed the lender on January 31st to stop onboarding new customers with immediate effect. In a press release, the RBI said that the nodal account of 197 communication and payment Paytm services are to be terminated at the earliest in case not later than February 29, 2024. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.